So the midterm's 2 weeks from today, and I haven't quite finished writing it, but it's 5 short answer questions. This is not a writing exercise, although I do insist on complete sentences, and 30 true-false questions. And I may need some help here. I need an Apple expert. Okay. I get a blank screen.
Just trying plugging it. Sometimes it takes itself out into thinking that it's plugged in. It's not. Did you just plug it in and just did that?
Yeah, actually, it played the played
The music and everything?
a slideshow, music and everything. Fine.
Sorry. Is that okay?
Sure. Stand up, stretch, relax, daydream. Be with you momentarily.
Is everything before?
No. It sometimes shifts formats here as opposed to at home. See? I don't want that.
Did it again?
There we go. Oh, it's come back. Okay. Took a while. Okay, so the midterm's 2 weeks today, 30 true false, 5 short answer questions. Let me say a couple words about the papers, which you can pick up at the end, and I'll leave plenty of time, so there's no rush, no zoo down here when you're going through. Don't muss my perfect alphabetical organization. A's are over here and going down the alphabet. Papers were pretty good. The class average score was 12, which is basically a B minus. Most of you were above that, some were well below that. Remember the Peter Cincotti number that I played on Tuesday? I changed the rules. I'm going to change the rules for the next paper because the swapping sign-offs that it's a well-written paper wasn't perfect. A number of you signed off on papers, put your signature on papers testifying that you had read the paper, that it was clear and well-written and contained no grammatical errors. And a number of you who signed on the dotted line that way either had not read the paper or didn't care whether it was well-written and contained no grammatical errors. And you know, when you sign something, you put your credibility on the line. And to sign something that isn't true is basically dishonest. Like for the laptop contracts. If you promised to use the laptops only for note-taking in class, well, you better do that and not do something else. Similarly, signing off as something that is not true is dishonest. So for the next paper, which isn't due until the middle of April, if you sign something that turns out to be badly written and full of grammatical errors, your grade will suffer by some significant amount. Sorry to be so mean about that, but I think there's a lesson here. That's fair warning. I should have done it this time. Fair warning for next time. A week from Thursday, we'll do a review for the midterm. Go over the material up to date. Focus on the big questions at the beginning of each section of the reader, and make sure you can answer those. And then bring to that class whatever questions you have, and we'll get everything answered that day. So let's go back to the Pentagon Papers and the whole subject of prior restraints. The Pentagon Papers decision, the per curiam decision by the court, as opposed to the 9 separate opinions of each justice. The per curiam opinion says, well, there's a heavy presumption against the validity of any prior restraint, burdens on the government to prove its case, the government didn't prove its case. And then in Justice Stewart's opinion, joined by White, he says that the burden is this on the government. It has to prove a grave, immediate, irreparable harm to national security in order to justify a prior restraint. And that's sort of the consensus position on what the standard is for granting a prior restraint. We'll come back to that in a little bit. A few years after the Pentagon Papers case, another really very interesting case arose involving the Progressive magazine, which is a little left-wing print magazine published in Madison, Wisconsin. And they assigned a writer named Howard Moreland, this in the mid-'70s, to do a story on the hydrogen bomb and how to make it, the recipe for the hydrogen bomb. He wrote a story called The H-Bomb Secret, How We Got It and Why We're Telling It. And after he had done all his research on how to make a hydrogen bomb from the resources, all of which seemed to be publicly available that he was able to research, he wrote up a draft of the article and sent it to the Department of Energy in Washington, asking whether you could check and make sure that I got this all factually correct. You can imagine the response, lawsuit. The Department of Justice responds to Moreland's inquiry with a lawsuit filed in federal court seeking an injunction against the publication of the article and seeking a preliminary injunction, an emergency order against the publication of the article. The judge, Judge Warren, who was his name, assigned to the case, agreed with the government that this article should not be allowed to be published, and he used as the standard for making that determination Justice Stewart's consensus position from the Pentagon Papers, that is, a grave, immediate, irreparable harm to the national security, and found that the government had met that standard. The judge distinguished, using the common law method, but this is all constitutional law, it's not substantively common law. He distinguished the Pentagon Papers decision, saying, well, the Pentagon Papers only involved historical data, nothing timely about it, and the only real danger, the judge knew this by 1979, when the case was decided, the only real danger presented by publication of the Pentagon Papers was embarrassment to government and military officials. While in the Progressive case, the Secretary of State had put in a testimony saying that publication, quote, would increase thermonuclear proliferation, and the judge was quite explicit about his risk aversion. Judges generally are not good risk takers, they're conservative people. And this judge was upfront about the disparity in risk between ruling for one side or the other. A mistake in ruling against the progressive, he acknowledged, would seriously infringe its First Amendment rights. But a mistake in ruling against the government could mean thermonuclear annihilation for us all. Our right to life would be extinguished, and the right to publish would become moot. He said during the argument on the preliminary injunction that he would have to think long and hard before he delivered the H-bomb to Idi Amin. Idi Amin was the dictator of Uganda and sort of an international pariah, the Saddam Hussein of his time. And he would be privy to the H-bomb secret published in this paper. The Judge Warren, in the Progressive case, cited as precedent Neer versus Minnesota, saying that the technical data about the construction of the H-bomb was analogous to the troop movements that were referred to by Chief Justice Hughes in the Neer case. The judge entered his order enjoining the Progressive from publishing, and the Progressive immediately appealed. And as the record was being assembled in the clerk's office, the transcripts, documents that had been filed in the court, and getting ready to ship it to the Court of Appeals sitting in Chicago, an underground newspaper in Madison, Wisconsin, published the article. And then the Chicago Tribune, mainstream, major newspaper, published the article. So that the appeal became moot. There was nothing that needed to be decided. There was no point in enjoining publication because the article was out there in the public domain, and indeed the Progressive followed by publishing its own article. The case was dismissed. The appeal was dismissed because there was nothing to decide. It's only a decision of a single federal judge, not a very strong precedent. But one of the interesting things about the Progressive case is that despite the government's insistence that publication would gravely harm the national security, there has never been any evidence of any harm whatever to national security because of the disclosure of this information. There was a little difference in the Progressive case from the Pentagon Papers case in that in the H-bomb case, there was a statute, the Atomic Energy Act, that called information like this restricted data and included data on how to make atomic weapons. And the statute specifically authorized the Attorney General to go to court and to seek a court order stopping publication of restricted data. That's real different from the Pentagon Papers situation, where, as you recall, during the argument, there's talk about separation of powers, and Bickel is telling the court, well, it would be different if there were a statute here. But in the Pentagon Papers case, there wasn't, and the president was insisting that he had inherent power as president to stop publication of the Pentagon Papers. And that resonated with several of the justices who thought that presidential power is not limitless, and it makes a difference whether Congress has passed a law authorizing the executive branch to take such dramatic action. Well, they had done so in the Progressive case, which made the case somewhat easier for the Justice Department to win. So, to sum up what we know about prior restraints, our law has always been hostile to them from the very beginning. It's true that there is no absolute prohibition against prior restraints. We know that from Neer, we know that from the Pentagon Papers, we know that from the Progressive, that in an exceptional situation, a prior restraint might be justified. Because the court was splintered all over the place in Pentagon Papers, no clear standard was made explicit in the Pentagon Papers decision, but as you see in the Progressive case, it's become generally understood that the standard is the government has to prove grave, immediate, not necessarily in a temporal sense, but in a causal sense, definitely follows, directly follows publication, grave, immediate, irreparable harm to the national security. And I have to tell you that the prior restraint rule is not limited to national security situations. There have been prior restraints issued in other contexts, not involving the national security, but involving some other vital national interest, including the protection of constitutional rights. So it's not just national security, it's some vitally important government interest that would be gravely, immediately, and irreparably harmed in order to justify a prior restraint. But because this is a predictive enterprise where you have to predict what harm will follow, it's a dangerous restriction on free speech. Lena. Is that the proof? Oh, strict scrutiny. No, this is not a content-based restriction on the substance of speech. It's a procedural gimmick. It's censorship before the speech is even heard. And we can assume, this is an odd thing about prior restraints, there's really no dispute about enjoining issuing a prior restraint against protected speech. If the speech is protected, the government has no business enjoining it and no business punishing it after the fact. So we're dealing by hypothesis here with unprotected speech. You could assume that disclosing the information in the Pentagon Papers would violate the Espionage Act, would not be protected speech, could be punished after the fact. But that doesn't mean that the government can stop publication. It has to wait and see, and then punish after the fact. The prior restraint isn't permitted. We have to care about whether something is a prior restraint because judges are conservative people and are likely to be too conservative in their predictions of harm based on what they think is a convincing government showing. And we know that if it is a prior restraint, that triggers the rule that there's a heavy presumption against its validity and that the burden is on the government to make that showing. Is the Pentagon Papers case a press case? Is it about freedom of the press? Any thought? It's certainly, it was a New York Times case, and they were about to publish. And some of the justices, like Justice Black, emphasized that this is the proper role of the press to uncover the secrets of government and inform the people. Despite that rhetoric, the court does not rely on the press clause in its decision. And the principle of the case, the rationale of the case, extends to speech by all of us. Not just the press can't be stopped from publishing, but we can't be stopped from saying what we want to say or publishing what we want to say, even though we're not the press. So the principle is of much broader application and it's not really a press case. It is one of the three pillars that I've mentioned before of our First Amendment freedoms that make our freedom real, make us a free people, and distinguish us from other countries. Pentagon Papers is one, no prior government censorship of speech. That's one pillar. The other one is Brandenburg that we looked at, that we have the right to advocate dangerous ideas, harmful ideas, as long as it doesn't amount to incitement of imminent lawless activity. And the third pillar, we'll get to in 2 weeks, New York Times versus Sullivan, and the right that we all have to criticize government. Note also that for those of you who are uncomfortable with corporations having First Amendment rights, that the Pentagon Papers involved the speech of a corporation, the New York Times, resulting in a First Amendment decision that protects all of us. It's somewhat surprising, just recently this book came out, No Easy Day, written by, we now know his name is Matt Bissonnette, who was one of the Navy SEALs who went over and killed Osama bin Laden, and he writes a book about it. And the Pentagon knew the book was coming out before it came out. He tried to publish it anonymously, but he knew it was coming out. And the government didn't attempt to get a prior restraint. Somewhat surprising, isn't it, that the Pentagon wouldn't attempt to shut that down, because it looked like at least he was going to be disclosing classified information. It certainly hadn't been public information. And they didn't do it. Why do you suppose they didn't do it? Yeah?
Little biased, but in a lot of these cases, they're trying to get away from it. They're fearful of it, it's bad, but I mean, that's why the Bin Laden assassination is such a triumphant thing for America. I think that they're in good stand there.
Because it was a triumph for America, therefore it should be disclosed, even though it would disclose methods, operations.
I don't necessarily think so, but I think that the government gave some leniency to some positive press that was good.
Yeah, there was some suspicion to that effect that the government was a PR thing, that the government really wanted to, right before the election, to get that out there, remind people that the Obama administration had found and eliminated bin Laden. Yeah, I think technically, certainly they had important meetings about this, where they got their lawyers in there, probably somebody from the Justice Department, and they said, look, can we make our case under the Pentagon Papers rule? Can we show that publication of this book will gravely, immediately, irreparably harm the national security? And my guess is that they made the judgment that they couldn't make it, that they would lose the case. Well, the Pentagon Papers case was, of course, precipitated by a leak. And leaks have become a big issue these days. The leaker of the Pentagon Papers, of course, was Daniel Ellsberg. Nobody knew that at the time the court was deciding the case. But it was Ellsberg who copied the 47 volumes of the Pentagon Papers and delivered them to the New York Times. Ellsberg was prosecuted by the government under the Espionage Act for violating the Espionage Act. He was called at the time the most dangerous man in America by Henry Kissinger, Nixon's Secretary of State. There's a wonderful documentary of that name, The Most Dangerous Man in America. It came out about 2 years ago. It tells all about Pentagon Papers situation, and I highly recommend it. Ellsberg, his prosecution was aborted in mid-trial.